Be ready. Start. Learned counsel for the appellant has argued that the will dated 4/9/1984 is not a registered document but is surrounded by suspicious circumstances which the propounder of the will has failed to dispel. Stop. This fact is admitted that the deceased had two daughters, namely Sito and Amarkor. Stop. The deceased had referred to his daughters Amarkor and Sito in the will. Stop. Sito had appeared as witness and has denied the execution of the will by her father, even though her son Paramjeet Singh is the beneficiary as per will of Labh Singh at the rate Teja Singh. Stop. Sito has stated that she is on good terms with Paramjeet Singh. Stop. DW1 Joginder Singh, one of the marginal witnesses of the will, has stated that Labh Singh Teja Singh died in village in the house of Tralok Singh Sarpanch due to attack of paralysis. Stop. Tralok Singh Sarpanch is the father-in-law of Harjinder Singh, one of the beneficiaries of the will. Stop. He has present at the time of the execution of the will as stated by Angrez Singh DW2, who is also one of the beneficiaries of the will and brother of Harjinder Singh. Stop. The points raised by the trial court terming the will as suspicious have not been referred by the first appellate court. Stop. It is mentioned in the will that Labh Singh at the rate Teja Singh was residing with beneficiaries of the will and they had been serving him. Stop. This fact is neither pleaded nor there is evidence to this effect. Stop. He has relied upon the judgment of Honorable the Supreme Court in the case of Bhagwan Kaur. Stop. Learned counsel for the respondents has argued that the first appellate court in para 11 and 12 of the judgment has elaborately dealt with suspicious circumstances pointed out by the trial court. Stop. The court has taken note of the fact that it is a tradition in the agriculturists in Punjab that they prefer the property to remain with the male heirs instead of giving the same to the female heirs. Stop. He has even disinherited his daughters Amar Kaur and Sito despite making their mention in the will. Stop. The substantial question of law which arises in this appeal is whether the finding about the genuineness of the will as recorded by the first appellate court are perverse and not based on proper appreciation of law and facts of the case. Question mark. As to whether the will is genuine document or not has to be decided on the facts of each case. Stop. The facts of the case and surrounding circumstances coupled with the quality of evidence are the factors to be taken into consideration while assessing the genuineness of the will. Stop. In the case of Honorable the Supreme Court has observed as under stop.